first. The Calvo administration is continuing to challenge a Ninth Circuit ruling on the tax return lawsuit filed in federal court. The Ninth Circuit Court last month affirmed the 6-month deadline ordered by the District Court of Guam. Now, the governor's office wants the entire Ninth Circuit panel to hear the case. While 2014 error-free Status A tax returns have been completely paid out well before the 6-month deadline, the case is still being challenged in court. Late last month, the Ninth Circuit Court of Appeals ruled on an appeal filed by the governor's office. The Calvo administration sought to appeal a ruling set by the District Court of Guam, ordering that the government pay out tax refunds within 6 months of the filing deadline. The Ninth Circuit, however, agreed with District Court presiding judge Consuelo Marshall, affirming the permanent injunction she issued. But the Ninth Circuit panel only included 3 judges: Marcia Berzin, Kim Wardlaw, and John B. Owens. The governor's office is now asking that the case be reheard en banc or by a full Ninth Circuit panel. However, the petition does not merely focus on the issue of tax refunds. The court documents also take into account the history of Guam's political status, noting that Guam's relationship with the United States as an unincorporated territory makes it so that the island acts essentially as a federal instrumentality that was created through an act of Congress. Therefore, the attorneys note, it is subject to federal immunity and cannot be held liable for attorney's fees. When the Ninth Circuit ruled last month, they also affirmed the lower court's order to grant attorney's fees for the prevailing party of about $2 million. But the governor's office disagrees with that ruling. Quote, Guam's status as a federal agency should have been dispositive, court document states. Courts have universally held that federal agencies, as distinct from states and local governments and their officials, cannot be liable for attorney's fees. While the governor's attorneys acknowledge that rehearing a case en banc is generally disfavored, they believe this case warrants being reheard en banc because, quote, the proceeding involves questions of exceptional importance. You can read the appeal on our website at pacificnewscenter.com.